Wills versus living trusts, which one is right for you? Matus Law Group. You've worked hard to build up your assets and you want to ensure that they're distributed properly after you pass. Both wills and living trusts can help you protect your assets and provide for your children after your death. It's important to consider different estate planning options to figure out which type of tool best suits your needs, and this blog will compare two of the most common. What is a will? A will is a widely known estate planning tool that outlines how you want your assets to be used after you pass. Not only does it describe how you wish your assets to be distributed, it allows you to name a guardian for your children. A will does not go into effect until you die. It goes through the court system. The court system ensures that the person's property is properly distributed and that the will is valid. Pros of a will. Allows you to name guardians for children. Names property managers for property given to children. Straightforward to write. Permits you to specify funeral and burial arrangements. Cons of a will. Must go through probate process. Entered into public record. Only includes property in your name when you die, not property in a joint tenancy or trust. What is a living trust? A living trust is a bit more complicated than a will, but it may offer additional advantages to beneficiaries. It does not have to go through the probate process, which may allow assets to be distributed more quickly and provide for the needs of your children promptly. A living trust goes into effect as soon as it is created and notarized. All property listed in the living trust is transferred into the trust's name. After the trust is created, you can add, remove, or distribute property if your circumstances change. Pros of a living trust. Avoids the lengthy and expensive probate process. Kept private and out of the public record. Can protect government benefits for beneficiaries with disabilities. May provide creditor protection to beneficiaries. Cons of a living trust. Requires notary public. May be more costly upfront when compared to a will. While both wills and living trusts can be of use during the estate planning process, it all comes down to your and your family's specific needs. For example, someone with grown children may not care that a living trust does not allow them to name guardians. On the other hand, someone with young adult children with significant disabilities may consider that a top priority in their estate planning needs. Your estate planning efforts can impact your children and other beneficiaries for the rest of their lives, so it's important to cover all of your bases and meet all legal requirements. Get help with your estate planning needs. Call the team at Matus Law Group at 732-281-0060 to get started.